Paul. Yeah. This this reality, yeah, that a lot of persons are experiencing because of their personal experiences. Yes. An email sent by Mr. Budnick on Friday, June 16th of 2017. Yeah. Including people at Heidi Budnick's workplace. Yeah. I didn't get a copy of that. Now, for some reason, you think that you have the right to admit people to mental institutions without actually giving them the right to see the evidence. Now, I just learned about this requirement of law as being different than this, where you have a court hearing, yeah, to reissue the temporary protection order, yeah. But the petitioner didn't acknowledge it. Did she motion the court to do that? Because I found that really upsetting, yes, because if she doesn't acknowledge it when you issued it, how can you be in reality, Brent? Now, it could be that the Mormon way has affected the come to find out family, and I'm going to want to know what actual sexual fixations you have, because you're not living in reality. I am. Now, you reissued it without any attempt of service. Yes. Now, you had to reissue it, and you had to have another court hearing on the 12th of June. Yes. And the petitioner appeared in court and said, "No, I did not attempt to serve the respondent, because your excuse for everything that you've done fraudulent was that on July 8th of 2011, the petitioner left the island of Guam, right, ran into the court and said, 'My husband's crazy and he's tried to kill me.'" Pooch! But that wasn't reality. There's a possibility that my wife might have the insanity defense. Yes. Well, I didn't realize I was kidnapping his sons, but since we didn't give him any notice of court hearings, and we didn't have court hearings according to the minimum number of actual days that you could have had court hearings, yes, you could have had them, 2, 3 weeks later, 21 days later. Yes, you could have. Seems like these civil court procedures, it's kind of like, what do you need as a petitioner to make sure the respondent has notice of court hearings? Yes. And this concept of me concealing myself, hiding from actual court hearings, has never been a reality. Now, you decided to reissue it on the 12th of June? Yes. And then you had a court hearing 40 days later. Yes. When you can only reissue a temporary ex parte order for 14 days. And then the sheriff's department attempted 2 times to serve me. That's what it says. Yes. Because you couldn't serve the petitioner. She would have had to appear in court on June 12th of 2015. Now, are there some virtualized employees of Clallam County that took it upon themselves to decide that I was a domestic violence perpetrator and a child abuser? Did you decide that on your own, employees of Clallam County? Now, these 2 attempts of service, yes, they're both fraudulent. Pooch. And having a court hearing 40 days later violates the RCWs. Yes. It violates the Violence Against Women's Act and the issuance of court orders according to the requirements of the law of the state of Washington. The judge's manual will explain that to you, the 832 pages. Now, this order for protection, yes, and the order surrender weapons restriction, yes, and then the motion hearing, W. Brent Basden, you issued it for 10 years. You're not in reality. And then the return of service from the service of the individual that served me in the Sequim Public Library that wasn't the sheriff, had no legal right to know anything about my personal life or the lives of my sons. That was a wrongful execution and a fraudulent service on the part of the sheriff's department. Yes. And then you attempted service on somebody else? Yeah. You can't. Once the respondent is served. And then the return of service on 8/27 of 2015? Yeah. Did you want to tell me who it was that you actually served on August 27th of 2015? Considering the fraudulent, yes, humiliating, degrading service, where you involved all the patrons of the library where I was sitting at the computer? Yes. Could it be that the Clallam County Sheriff's Department is not living in reality? Now, I'm going to want to look at exactly what the effect of having a dog has had on your real thoughts as a person. And considering there was a use of a forgery or possibly two forgeries of the ex-officio Superior Court clerk, yes. And then the arrest that took place for the allegation of the crime in Sequim, Washington, yes. The contempt of the restraint provisions. Oh, it wasn't a fourth degree assault, was it? No. You were saying I was stalking her? Well, even the individual that you served on August 27th of 2015 that thinks they're myself, I don't know how you would say it's stalking if from August 27th of 2015 to December 31st of 2015, yes, there was two confrontations that took place. They were verbal confrontations. There was some sort of verbal argument that happened. I don't know as I'd consider that stalking. Yes. Now, why don't we ask the Sequim Police Department? Because I think you're come to find out why. Yes, you are not in reality. Okay. Now, I was not in Sequim, Washington at 7:47 a.m. Pooch. But you arrested me without any actual domestic violence report. Yes. Not a real signature from an actual officer of the law that would have questioned the victim about exactly how she was hurt. No actual signature of the victim. Yes. No description of exactly what happened. No pictures of a fourth degree assault. Now, just reading the Domestic Violence Judicial Manual, all 832 pages of it. The use of a traffic citation, yes. We found out about the civil violation of the restraint provisions. Pooch. Now, when we go through, did you want to do that? Exhibit A, Jack? Poo. These restraint provisions that make it a contempt of court violation to contact the actual. See, it says here, respondent is restrained from coming near and having from any contact whatsoever. Yes. In person or through others by phone, mail, or any means directly or indirectly, except for mailing or service or process of court documents by a third party. Now, I could have a third party serve documents. Yes, that's what it says. Except for mailing or service or process of court documents by a third party. Or contact by the respondent's lawyer with the petition, the minors named in the table above. Now, this third party that allegedly had received an email, I think it is actually a 2-count criminal complaint, yes, of not cyber stalking, though law enforcement never questioned me, the mechanisms of law enforcement. But it says, by any means, directly or indirectly, for mailing or service of process of court documents. Now, there is the possibility, okay. Was somebody trying to serve the respondent or the petitioner that is not myself? Yes, could have happened. You said that they violated the restraint provisions of page 2 of 6? Yes. Or was it an actual verbal assault where someone had said to the petitioner or the 5 minors? Now, there is an exception to this restraint of the respondent. Yes, coming near and having any contact whatsoever. Yes, there is. Could you tell me exactly who it was that was trying to contact the petitioner? Considering she didn't sign it? Yes. Was it somebody that was trying to serve her documents that I didn't know of because I wasn't there? Considering that you served somebody documents that I don't know the identity of, and you never told me what the fuck they